All right, let's dive into something that can drive homeowners absolutely nuts. Can your HOA legally lock you out of a committee meeting? It sounds simple, but it's not. In fact, we're going to look at a real-life case where the whole thing came down to the definition of just two little words.
So let's put you in this situation. You pay your dues, you follow the rules, but then you find out a committee in your neighborhood is meeting and you're told, nope, you can't come in. Can they actually do that? It just feels wrong, right? Well, one homeowner thought so too, and it kicked off a major legal fight.
So this whole thing went down in Scottsdale, Arizona, at a place called the Desert Mountain Master Association. Back on September 6, 2017, a homeowner, Gary Moselle, tried to go to a communications committee meeting, but he was turned away at the door. That one act set off a legal challenge that ended up clarifying the law for pretty much everyone in the state. To really get what's going on here, we have to look at the law itself. I mean, the entire case, every argument, it all hinged on how you interpret Arizona's open meeting law for communities like this. And, the language seems pretty clear at first, but there's this one tiny detail that creates a huge gray area. So the law kicks off with this big, broad statement. It says, flat out, that the policy of the state is for meetings to be open. And it even says that if there's any doubt, the law should be interpreted in favor of openness. So right off the bat, you'd think the homeowner has a slam dunk case, because the spirit of the law is all about transparency. But then you dig a little deeper into the specifics, and bam, there it is. The law says all the big meetings, the board of directors, the whole association, have to be open. But for committees, it adds two crucial words: any regularly scheduled committee meetings. That phrase, regularly scheduled, that's the whole ballgame. What on earth does that actually mean? And isn't that crazy, this whole legal battle? All the arguments, all the filings. It all boils down to defining just two words. The homeowner had one idea of what regularly scheduled meant, and the HOA had a completely different one. It was up to a judge to figure out who was right. Okay, so here were the two sides. The homeowner's argument was pretty simple. Regularly scheduled just means a meeting that was, put on this schedule. It was planned in a normal, regular way, so it should be open. But the HOA said, not so fast. They argued it meant something much more specific, a meeting that happens at predictable intervals, like clockwork, the first Tuesday of every month or every quarter. So the homeowner kept pointing back to that big picture idea of transparency. But the HOA came back with a really powerful piece of evidence to back up their side of the story. They said, look, this communications committee doesn't meet all the time. It only gets together when it's needed. And they had the receipts to prove it. Just 4 times. That's it. In 2 whole years leading up to this incident, this committee only got together 4 times. That single number became the cornerstone of the HOA's case. Their argument was, how can you call something regularly scheduled when it happens so randomly and so rarely? It's not predictable. It's not recurring. It's what you'd call an ad hoc committee. So you've got these two totally opposite interpretations, and both sides have decent arguments. The decision fell to an administrative law judge who had to look at everything: the law, the evidence, the intent behind it all, and finally solve this 2-word mystery once and for all. And the verdict came down, and it was decisive. The judge sided with the HOA. The court's ruling was that the association did not violate the open meeting law by closing that meeting. And of course, the most important part was the judge's reasoning. The judge basically drew a line in the sand and gave everyone a clear legal definition. Regularly scheduled doesn't just mean it was planned. It specifically means a meeting that happens at predictable, regular intervals. And since the Communications Committee met so sporadically without any set pattern, its meetings just didn't qualify under the open meeting rule. And this wasn't just a quick decision either. After the judge first sided with the HOA in December 2017, the homeowner actually asked for a do-over, a rehearing. The case was looked at all over again, and in May 2018, the judge confirmed the original decision. That second ruling basically cemented this interpretation as the legal standard for HOAs in Arizona. Okay, so a case from Scottsdale, Arizona. Why should you care, right? Well, this ruling gives us a really powerful blueprint for understanding your rights and the limits of those rights when it comes to HOA committee meetings, no matter where you live. So here's the bottom line for you. First, the exact words in your state's law matter more than anything. A general feeling about transparency doesn't beat a specific rule. Second, you have to know what kind of committee it is. If it's a standing committee that meets every month, yeah, it probably has to be open. But an ad hoc committee, one that just forms for a specific task and meets a few times, it might be a different story. And third, and this is super important,
Remember, this ruling is very specific. It only applies to certain committee meetings. Your right to attend the big meetings with the full board of directors or all the members is almost certainly still protected.
And all this leaves us with one last really big question to think about. Is this a good rule? Is it a practical way to let small temporary committees get things done without a lot of fuss? Or is it a giant loophole that lets HOAs move important business behind closed doors away from public scrutiny? That debate over the line between efficiency and secrecy, well, that's a conversation happening in communities everywhere.